Alex here with part 146 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my access parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go now into the court's order regarding my motion to modify child custody. As with my previous videos, I haven't looked at this order in advance, so I'm not quite sure what's inside of it. I would have thought that it involved... Well, no, I already set the hearing. So I'm imagining that for some reason or another, I have to reset the hearing. I'm not quite sure why, but it could be because the judge is recusing himself. But now that I say that, he hasn't really done that yet anyway. It is coming up in the series, but I don't know how many further parts down the line. Given the fact that I have an attorney now and that she has a great reputation, I think my mindset is much, much higher. I was much more confident. It didn't feel as scary anymore. I felt like the self-representation bias that had been used against me for so many years was now going to work in my favor, as frustrating and unfair as it is. In fact, if you want to know the details on what I'm talking about, please watch my video, Self-Representation Bias. In any event, this is going to be one of those videos that I think is quicker and shorter, and for those several reasons, I am going to just go ahead and get straight into what the judge has filed. Here we have the order regarding motion to modify child custody. This is the first paragraph, standard introductory paragraph entered by the judge. He is indicating that he has reviewed my motion to modify child custody filed February 25th, 2014, including my ex's opposition and my reply. The judge goes into the next section here, which is that I filed motion for leave of the court to allow limited discovery, seeking permission from the court to request discovery from Child Protective Services relating to 3 alleged reports involving my ex and their child. I state that I have filed my motion to modify custody in large part due to my ex's dental and educational neglect. The contents of the reports from CPS may contain relevant details concerning allegations of abuse and neglect and may support the aforementioned motion. It goes into the next assertion or paragraph here. On April 17th, 2014, he entered an order referring the matter to the Discovery Commissioner, and then he goes into the final section, which is that based on my representations, the court finds that the requested discovery is directly related to my motion to modify child custody. In order for the court to fairly adjudicate my motion to modify child custody, the court has to first enter a decision regarding my motion for leave of the court to allow limited discovery. Therefore, the court thinks that it's appropriate to hold my motion in abeyance pending the decision from the court regarding my motion for leave. I do have an opinion here. There is a Supreme Court rule that does not allow this to be delayed beyond 6 months. When did I file this motion? I filed the motion February, which May, June, July, August. So it should have been decided by August, which is looks like we have some time. It's only been about 2 months, so this is a fair move by the court to delay this. And what he wants is to get the information regarding the CPS reports. So that's what he's doing. He is going to hold this matter in abeyance. And wait, I see what he says. You have to file a motion. Okay. And he wants us to resubmit, which what he's saying there, it's not clear, but what he's saying is that he wants me, or I guess now my attorney, to file a request for submission once the motion for leave of the court has been adjudicated. Okay. That makes sense. It's logical. Certificate of service by mail. He is indicating that he electronically served both my attorney and my ex's attorney. Going into the next document. Notice to set. Okay, my attorney intends to appear telephonically at the hour of 10:30 a.m. to schedule an evidentiary hearing in the above entitled matter. What is it for, though? An evidentiary hearing for the motion to modify? It's not clear. I would assume that that's what this is about, even though We haven't gotten an order back from the commissioner, the discovery commissioner. Maybe the order from the discovery commissioner is not entered until a later date. That could possibly be what's going on here. And that might be coming up either in the next video or in the video after that in my docket series. But if my attorney is trying to set this for an evidentiary hearing, then I would assume that that decision has come down from the discovery commissioner, and we're going to see it very shortly. So again, guys, if you want to know what a notice to set is, please watch my video, Notice to Set. This is like a one-page piece of paper that might make it seem like it's not really that important. But in actuality, this notice to set process is pretty convoluted, in my opinion. It confused me in the past. I think it confuses a lot of people. So watch the video Notice to Set to learn more about how it works. And then a certificate of service under Rule 5, which is indicating that this attorney has mailed a copy of this notice to set to my ex's attorney. Going into the aftermath, the court has filed, well, we don't really track the court. I have filed one document, the notice to set, but it was a free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. My attorney would have probably spent 15 minutes on this document. Reviewing the order, negligible. All it does is say, hey, request for submit once this other thing is resolved. So, you know, at most we're talking 5 minutes there. And the notice to set, I think combining these two documents, setting them at 15 minutes at the rate of $500 an hour, bringing it to $125 in attorney fees is pretty accurate, considering these this document specifically, the notice to set, is just one of those copy paste that you just check. You can even see here that the worker just even marks it with a checkbox and electronically signs it. So very standard run-of-the-mill documents. So $125 in attorney fees for me, I think is pretty fair. My ex's attorney, I would say the same thing. She's going to have to at least review this document, set it to her calendar, review the order. I think 15 minutes is reasonable. And at the rate of $250 an hour, will come to $62.50 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below. And I will see you guys next time.